Today, I am going to discuss all about the suit of civil nature. Section 9 of the CPC 1908. It simply stated that the civil court has jurisdictions to try all the suits of civil nature unless expressly barred. The first part of this expression opened the door to the court to entertain a suit of civil nature, whereas the later part of this expression debars a court to take cognizance of the suit of civil nature. The exclusion of jurisdiction is legislative in nature, and the legislature is competent by implication of a statute exclude the jurisdiction of civil court. Let us take an example. Section 170 of the Representation of People Act 1951. It lays down that no civil court shall have a jurisdiction to challenge the validity of the actions taken or decision given by a returning officer or any person authorized under this act in connection with the election matter. Further, we take another example. Section 175 of the Motor Vehicle Act 1988. It lays down when any claim tribunal is constituted for an area, no court shall have a jurisdiction to entertain a question relating to the claim for compensation of that area which may adjudicated upon by the claim tribunals. Therefore, I have given two illustrations, and it has become clear that the legislature by the implication of a statute exclude the jurisdiction of the civil court. Now let us discuss some another material fact. A suit in which right to property or to an office is considered, it is a suit of civil nature. A suit in which question relating to the religious rites and ceremonies, it ceases to be a suit of civil nature. But in a suit, the question relating to the religious rites and ceremony may be adjudicated in order to decide the principal question which relates to the right to the property or to an office. Now I am giving here some illustration in which there is no determination of right of the property or to an office, but it is the principal question of religious rites and ceremonies. As for instance, the question for the determination of religious rites and ceremony, it is not a suit of civil nature. The question relates to the caste question, the suit upholding the dignity and honor. Further, a suit for the recovery of payment voluntarily made in offering, or a suit against the expulsion of a person from his caste. All these suits are the example where there is a principal question relating to the religious rites and ceremonies. Therefore, this is not a suit of civil nature, because there is no determination of the right of the parties with respect to the property or to an office. What is Section 9 says? Section 9 lays down that the civil court shall, subject to the provision herein contain have jurisdictions to try a suit of civil nature unless it expressly or impliedly bar. Further, it made it clear in the explanation 1, and it is stated a suit in which right to property or to an office is contested. It is a suit of civil nature, notwithstanding the determination of such right entirely depend upon the determination of question relating to the religious rites and ceremonies. An explanation 2 is added by amendment in the year 1976, and it made it further clear that it is immaterial whether any fee is attached to the office or whether any office is attached to the particular place. A civil court have a jurisdiction over a suit. Two things required to be satisfied. The suit must be a suit of civil nature, and it must not expressly or impliedly bar by any statute. Therefore, the civil court have a jurisdiction. There must be a suit of civil nature. What is the meaning of civil nature? The term civil is nowhere defined under the provision of code, but its dictionary meaning is the right and the remedy of the citizen. Nature means the fundamental quality of a person or thing or essential characters, sort, kind, etc. Therefore, in a suit in which principal question relates to the civil right and its enforcement, it is a suit of civil nature. The suit of civil nature is to be determined not with respect to the status of the party, rather with respect to the subject matter of the suit, and it is only the subject matter which can decide whether or not it is a suit of civil nature. Therefore, the civil right only includes the right to the property and to the office, and it does not cover the political and criminal question. Therefore, in a suit, if the principal question relates to the right to the property or to an office, it is a suit of civil nature. And if the principal question relates to the determination of religious rites, ceremonies, or the caste question, it ceases to be a suit of civil nature. But if the principal question in a suit relates to the civil right, that is the right to the property and to an office, but the adjudication incidentally involves the determination of question relating to the religious rites and ceremony, it does not ceases to be a suit of civil nature. One thing is required to be made it clear that prior to 1976, there was a divergence in the judicial opinion whether a suit which was filed relating to the religious office to which no fee was attached, whether it was a civil suit or not. Therefore, after the amendment made in the year 1976, it made it clear that it is immaterial whether any fee is attached to the religious office or not, or whether a religious office is attached to the particular place or not. Therefore, a suit is said to be maintainable irrespective of fact whether any fees is attached to the office or not, or whether the religious office is attached to the particular place or not. Therefore, I have discussed about the suit of civil nature. But there is always presumption that and it can be readily inferred that the civil court has a jurisdiction to try the suits of civil nature. But the provision of exclusion, if a suit is excluded by the implication of a statute enacted by the legislature, it should be construed strictly. Therefore, the relief, if the relief granted or the remedy given in a special tribunal constituted by the statute is not sufficient, or if all the relevant question has not been adjudicated by the special tribunal, then the jurisdiction of civil court may not be ousted, and therefore the civil court may have jurisdiction to entertain a suit if the tribunal constituted by a statute fails to determine all the question relating to the fact of the case. Now, the question is expressly barred. The expressly barred means barred by a statute enacted by legislature. The legislature is only competent to exclude the jurisdiction of civil court for the suit of civil nature, and the legislature in doing so must keep itself within the field of legislation which is conferred on it, and does not act in contravention of the provision of law. Therefore, there is always a presumption in favor of the civil court that the civil court has a jurisdiction to try all the suits of civil nature. But the exclusion provisions are also there, as for instance the matter falling under the revenue code or the code of criminal procedure code. It excluded the jurisdiction of civil court. Likewise, certain matter dealt by the special tribunal constituted under the statute also debarred the jurisdiction of civil court, as for instance the industrial tribunals, the electricity tribunals, the MSc tribunals, the election tribunals, and also are the several tribunals, and if the matter is so decided by the tribunals, then the jurisdiction of civil court is barred. But I have already stated, if the tribunal does not provide a adequate remedy and all the relevant question has not been decided, it does not exclude the jurisdiction of civil court, and the civil court will have jurisdictions to try the suit in that situation. Impliedly bar. What do you understand by the term impliedly bar? A suit, the jurisdiction of the suit is said to be impliedly barred if it is barred by the general provision of law. If the relief granted, if the remedy given by a tribunal constituted under a statute has decided the same matter, has given the same relief, in the sense, what is the power of civil code, that in that situation it can be said that there is a implied bar about the jurisdiction of civil code. Further, it made it clear that what is the intention of legislature as to the enactment of a statute. What is the intention? If there is an intention in the tribunal constituted under a statute, then the jurisdiction of civil code can be excluded. In certain situations, the civil code has a jurisdiction to try a suit of civil nature, but the civil code ought not to have take cognizance as it injured to the public policy, or if it is against the interest of the public in general. As for instance, no suit shall be lie for the recovery of expenses incurred in a criminal prosecution. Therefore, it is against the interest of the public in nature. Further, the civil code may not try a suit as to the enforcement of contract which is heeded by sections 22 of the Indian Contract Act. As for instance, if the person entered into a contract for the immoral act, or entered into a contract to defeat the provision of law, then in that situation the court shall not have a jurisdiction to entertain a suit. Further, the court may not entertain a suit for the action taken by the judicial officers in the discharge of his duty. There are certain situations that the jurisdiction of the civil court is excluded. Even in that situation, the jurisdiction of the civil court is excluded by the implication of a statute. But even in that situation, the civil court will have jurisdiction to entertain a suit in order to examine whether the provisions and the rule made under the statute has or has not been completely complied with. The civil code has a jurisdiction to consider whether or not there is a violation of principle of natural justice, or the tribunal has not followed the rules of evidence. Therefore, in all these matters, though the civil court has no jurisdiction, the jurisdiction of the civil court is ousted by the tribunal constituted under a statute. But even in this situation, the civil court will have a jurisdiction to entertain a suit. Now the question is, which is in power to decide the jurisdiction of the court? Section 4, Order 14 of the CPC clearly lays down the civil court has an inherent power to decide the matter relating to the adjudication. Therefore, whether the civil court has or has not adjudication, whether or civil court has or has not jurisdiction upon the subject matter of the suit, the civil court has inherent power to decide the jurisdiction relating to the subject matter of the suit. Now the question is, who is who is to prove the exclusion of jurisdiction. A person's a party to the suit who seeks the ousting of the jurisdiction of the civil court has to prove that this matter is completely to be dealt by the tribunal constituted under a specific statute. Therefore, it is the party who challenges the jurisdiction of civil court has to prove the fact that the regular court, the civil court, has no jurisdictions to deals the matter. Now, what are the suits of civil nature? Where there is a right to property, where there is a right of worship is in question, where there is a right of the dissolution of marriage, and there are several rights which can be said that it is a suit of civil nature, but there are certain matter which cannot be supposed to be a suit of civil nature, as for instance, if the principal question is for the determination of religious rites or ceremony further in a suit in which there is a question of caste question, further in a suit upholding the dignity and honor of a person, further a suit for the recovery of payment voluntarily made or in offering, or a suit against the expulsion of a person from his caste. These are the examples which cannot said to be a suit of civil nature. Therefore, I have discussed all about the jurisdiction of the civil court, and I hope it will help you to form a better conception about the jurisdiction of civil court. Thank you.